Have you ever wished you could just hit a pause button on a disaster right before it happens? Well, in the legal world, you actually can. Today, we're diving deep into one of the most powerful tools a court has, the preliminary injunction. Think of it as the law's emergency brake, and we're about to see exactly how it works.
So, picture this. Something catastrophic is about to happen. A competitor is about to leak your company's biggest trade secret. Or maybe your neighbor just started pouring concrete on what you're sure is your land. You can't wait months, let alone years, for a full trial. You need to stop the damage right now. This is where this legal tool becomes a total game changer.
So here's our game plan for today. We're going to start with what this legal pause button actually is. Then we'll run through the checklist of what it takes to get one. After that, we'll get into the really high-stakes stuff, the emergency orders. We'll even flip the script and look at the defendant's playbook. And finally, we'll see how this whole thing wraps up in the endgame.
All right, let's kick things off with the fundamentals. What exactly is this legal pause button? And what's its whole point?
You can really just think of it as a court-ordered timeout. It literally freezes the situation to, well, stop the bleeding, while the court sorts everything out. The main goal here is to preserve the status quo, which is just a fancy way of saying it keeps things exactly as they are so the problem doesn't get any worse before a final decision can be made.
Now, not all of these orders are about telling someone to stop. They come in two main flavors. The first is prohibitory. Pretty straightforward. It prohibits someone from doing something, like halting construction. The second type is mandatory. It mandates an action, like forcing a company to reconnect a power line they shouldn't have cut. Courts are way more careful about issuing mandatory ones, because you're not just freezing the situation, you're actively making someone do something.
Okay, so how do you actually get a court to give you one of these? Well, it is not easy, and that's by design. The law sets a really high bar, with a strict checklist to make sure this incredible power isn't just thrown around.
First, you got to convince the judge you have a really, really good reason. You need to show one of three things. One, that you have a clear, undeniable right to what you're fighting for. Two, that you're going to suffer a serious material injustice if the court doesn't step in. Or three, that what the other person is doing will make any future victory in court completely worthless.
And once you have your why, you have to follow the how to the letter. First, you file a verified application. That means you're swearing under oath that everything you're saying is true. Second, you post a bond. This is basically a security deposit to cover the other side's damages if it turns out you were wrong. And third, you have to formally notify the other party. You can't just get a court order in secret. Everyone has to be in the loop.
Okay, but what if you don't have time for all that? What about a real ticking clock emergency where waiting even one day is a disaster? Well, that's where things get really intense. Let's talk about the TRO.
At its heart, the whole legal system is supposed to be about fairness. So the main rule is simple. A court can't just order you to do something or stop doing something without hearing your side of the story first. That notice and that hearing are fundamental.
But the law isn't naive. It knows that emergencies happen. If there's a real risk of great or irreparable injury, a court can issue a temporary restraining order, or TRO. It's an even faster, more immediate order designed to stop the damage before any kind of formal hearing can be organized.
And the clock on these things is incredibly tight. In a situation of extreme urgency, a judge can issue a TRO for just 72 hours, sometimes without even hearing from the other side. But that starts a countdown. The absolute max life of a TRO from a trial court is 20 days, period. If a preliminary injunction isn't granted by then, the TRO just vanishes. Poof, no extensions.
And here's where it gets interesting. Not all TROs are created equal. Their power, their lifespan, it all depends on which court issues them. As we just saw, a trial court TRO has that super strict 20-day limit. But if you go up a level to the Court of Appeals, it can last for 60 days. And if a TRO comes down from the Supreme Court, it can last indefinitely, until the court says otherwise.
Okay, let's flip the script. We've been talking about how to get one of these orders. But what if you're the one on the receiving end? What's your playbook then?
So, imagine you've just been served with a court order telling you to stop what you're doing. It can feel like a huge punch to the gut. But you are not powerless. The rules give you a clear set of options to fight back.
You've got a few key moves. You can attack their application and argue it's just not good enough. You can file your own sworn statements, called affidavits, with your version of the facts. You can argue the order is way too broad and ask the judge to narrow it down. And here's a real power move. You can file a counterbond. That's where you tell the court, hey, I'll put up my own money to cover their potential damages if you lift this thing.
All right, we've seen the emergency orders, the frantic hearings, the legal battles. Let's fast forward to the finish line and see how this all gets resolved once the main trial is over.
Now, this is a huge procedural trap, so pay close attention. Remember that security deposit, the bond, the applicant posted way back at the beginning? If the court ultimately decides that the injunction was wrongly granted, you can claim damages from that bond. But, and this is a big but, you have to do it in the same case before the final judgment is entered. If you wait and try to sue later, you've missed your shot. It's a real use it or lose it situation.
And here we are at the finish line. If the applicant actually wins the whole case, that temporary pause button we talked about gets upgraded to a permanent stop sign. The court issues a final injunction, and that temporary order becomes a permanent part of the final judgment, forever restraining the other party.
And that really brings us back to the core issue here, doesn't it? The power to stop someone's actions, to restrict their freedom before they've even had a full trial, is immense. It's huge. So the question we're left with is this: how do we make sure this powerful tool is always used as a necessary shield for justice and never becomes a sword to gain an unfair advantage?